We would also be taking aim at companies that receive incentives after they've moved. One of the dirty little secrets in the incentives war is that there are a lot of companies that receive incentives months, even years after they've undertaken their move. There was a pretty notable case out of Durham, and one which is the subject of one of the cases that I've been prosecuting on behalf of the Institute. That was a company that received a $100,000 incentive 5 years after it contracted for its facility in Durham County.
So just to clarify this for folks, they're getting an incentive basically to lure them to Durham County 5 years after they've been there?
Exactly. It's scandalous.
Now, in putting together a but-for clause, then if it were done correctly, there's no way that a company could get some sort of grant or break like that, could it?
Correct. And the other part of a but-for test would require clawbacks. We would require on the front end a company to show that but for the incentives, it wouldn't come to North Carolina or stay here if it's already here. And the second part would be an after-the-fact analysis. Let's require the companies to show that they have fulfilled the promises that they made to get the incentives, and if they haven't fulfilled those promises by hiring the promised number of new employees or making the promised capital investments, let's require that they pay back that money.